and I'm not seeking any 15 minutes here. I could say the same thing by taking Amber Heard as a client for you.
Fair game, right?
Article that says, quote, Johnny Depp is Hollywood's most overpaid actor for the second year in a row. Did you recall reading that?
I know, was that written?
I'm not sure if Johnny Depp just said that's right.
He asked her what she would like for him to cook. That's hearsay, I guess.
I know, I just...
Don't do this at home. Not what you want your expert doing. Well, hello, everybody. Mark Breyer from the Husband Wife Law Team, a real-life trial lawyer, not just a lawyer, not just someone who talks about the law. I actually get in there. I do the things like we're going to talk about today. Today, we're bringing it back to a classic, the biggest trial in this country since O.J. Simpson, the Johnny Depp Amber Heard trial, and we're going to go over some of the funnier parts of it, but I'm going to give you a little bit of a trial lawyer's perspective. Now, listen, couple things. Number one, thank you. So many subscribers, but right now, if you haven't subscribed, you should feel like you're left alone. Hit that subscribe button. Join the rest of the growing crowd of people that want to hear this content and real information about what actually happens in trial, not just what people think or say from the outside. And we've been getting a lot of contact from people going, well, hey, I understand you're a lawyer. How do you, listen, if you ever have questions, you don't have to worry, there's no sales pitch here. If you're ever just like, man, I wish a trial lawyer could just answer this question, go ahead and give us a call. The number's on the screen. We're here. We're here to answer questions, no pressure. It's what we do. With that said, let's get into some of the funny parts. Now, Amber Heard, Johnny Depp, for those that may not remember, because y'all knew it one time, for those that may not remember, Amber Heard came out with a piece that she published. It was basically part of an op-ed. She implied Johnny Depp, her by now ex-husband, had committed some domestic violence. He sued her for defamation, which is much harder than it sounds because there's a lot of protections for the media. These are actually really hard cases because we're kind of balancing the right to allow people to speak and the press to speak with people being falsely accused of things. But when you're a celebrity like Johnny Depp, that's actually super complicated. So he did not sue her in California, where I think they both lived at the time and where everything allegedly happened. He found a way to sue back in Virginia because they have better defamation laws called forum shopping. And so the trial actually happened, y'all, and it was a massive thing. Let's go back through some of the fun parts and I'll give you some insight.
Rocky's boyfriend, who was some sort of chef, he asked her what she would like for him to cook. That's hearsay, I guess.
I know, I just sure offered for the truth of the matter asserted.
He got it.
Okay, all right, well then.
I'm learning.
There you go.
He'd had a conversation with Ms. Heard.
Hearsay, Your Honor.
Here's the thing about Johnny Depp in this trial, and I saw enough of him to say, don't do this at home. Most people will not testify the way Johnny Depp did. If you ever find yourself in that position and you go off and start doing things and acting the way he did, you will not get away with it. Prompting the other side to object halfway through your question because you think they're going to could make you look like a total wise ass to the jury that they totally don't like. He gets away with it. Really, really bad idea for most people.
He said, yes, they had. Okay. And it appears that Ms. Heard had told...
Hearsay, Your Honor.
I'm not sure.
By the way, the problem with multiple hearsay objections is you're saying to the jury, I don't want you to hear this. And usually there's a way around most hearsay objections, not if it's core piece. You keep objecting and you take the risk that the jury's like, oh, they didn't want me to hear, they're hiding something. That's a risk. Hearsay is an out-of-court statement offered for the truth of the matter asserted. Hearsay is basically, you told me something, now I'm testifying. No. If someone told me, they have to come and testify. I don't get to say so-and-so said because it's not reliable. Now here's the thing with hearsay. Some things are not hearsay. For instance, if you're the other party and you said something like you admitted you did it wrong, it's not hearsay. So I'm allowed to say you said it. And there are literally 20-some exceptions to the hearsay rule. And there's kind of an omnibus exception, which is basically in English, yeah, but it's pretty reliable. There are as many exceptions to the hearsay rule as the hearsay rule itself.
This is apparently a statement by Ms. Heard.
By the way, the reason said a statement by Ms. Heard is therefore, if a party says it, it's not hearsay.
I have other uses for your throat which do not include injury. I have other uses for your throat which do not include injury.
Sorry, could you read that again?
These are your words.
Let's talk about the lawyer here, right? The lawyer thinks he's got gold, right? Because he's trying to make out Johnny Depp at this point, and this is his job, as you may be all very calm and friendly and nice here on the stand, but you actually, we have video of you screaming and ranting and approaching violence. This kind of statement towards the person that you love, this is going to be offensive. And so what does the lawyer do? The lawyer wants to hammer it home. There's a lot of ways to hammer it home by taking that statement and asking multiple questions about it and keeping the discussion about it. Repeating it twice, usually you get away with it. You don't want to look like you're pandering to the jury, right? And one of the things you don't know about this jury, because juries are just a group of people, some people are going to roll their eyes and go, this is a couple talking to each other, who cares? And some people will be shocked and horrified and judge the people as a result. And so as the lawyer, unless you've done some focus groups or you try to get a sense of your jury, does this even matter to them, or do you think you found gold that no one even cares about?
I read that right, correct?
You did. Yes.
Did I read that right?
You certainly did, yes, sir.
Did I read that right?
You certainly did, yes, sir.
And you wrote that about the, did I read that right?
Yes, you did.
You can clip up this cross-examination. Did I read it right? Did I read it right? Did I read it right? But here's the thing. Sometimes you have found something in a transcript or somewhere else that this person has said or someone else has said about them that you're allowed to get into evidence. And you don't want them later coming back and saying, yeah, but that wasn't really what I said, or that's not what I meant. However, I think there are more powerful ways to drive that home, which is, and that is what you said. That's consistent with your recollection. You actually said this offensive thing that we're just talking about. So when I sit down and your lawyer stands up, you're not going to turn to the jury and suggest in some way that those weren't your words or you didn't mean it. Now, can you do that with everything? No, you have to wait for the key points to do it. You can play games with editing all you want. I love the University of Michigan because they are the best. If you check to make sure that the witness is agreeing, even though there may be different ways you could say that, I think that's the power of editing over the course of hours of cross-examination, confirming that the witness is not going to disagree that what you're saying he said has some value.
Did I read that right?
You continue to read them right, yes.
And you were drinking pretty heavily.
Were you there?
It's my question to you, sir.
No, I wasn't drinking that heavily.
We can, let's turn to the UK
It's
116,
definition,
please.
what you define as heavily, sir.
You poured yourself a mega pint of red wine, correct?
A mega pint.
Yeah.
I poured myself a large glass of wine.
Right.
Guys, this is great work by the cross-examining lawyer until the end. Cross-examination is about having your ammunition in order. If I ask you a question on cross-examination, I'm going to tell you this in case you're ever a witness and I'm cross-examining you, I am probably going somewhere. Sometimes I don't care what your answer is because you have made different statements or I have evidence on either side, and no matter where you go, I'm fine. Sometimes I know where I'm taking you. This lawyer knew where he was taking Johnny Depp. The reason he said you were drinking heavily and that you had a mega pint is I saw during this trial someone showed that he had actually testified to that about drinking what he called, Johnny Depp, a mega pint in other testimony. But the lawyer never impeached him on it. He never said, oh yeah, haha, mega pints. Okay, so those aren't your words. You didn't have a mega pint. Okay, so that's your statement under oath before this jury. Those are just me putting your words in your mouth. Now, I don't know if in some way the judge excluded that testimony or if what I was shown was incorrect, but I think that lawyer knew he had him. But in that moment, he lets Johnny Depp dance. When that's a moment to go, you are trying to be lighthearted and pretend like, I don't know, I wasn't there. I don't know if you were drinking. You testified. You called it a mega. Those are your words, aren't they? That was a great moment to totally start tearing apart at the credibility that this witness, that the adverse party has. I don't know why he didn't use it. If he had done that, all the wisecracking Johnny Depp does, if he's like, whoa, this lawyer is prepared and knows some things that I didn't even know this lawyer knows, guess what? They start falling in line. They go, okay, maybe you got me here. And if they don't, you just keep hammering them. It was great lawyering right up till the moment, and I don't know why it wasn't used, but it could have been critical, at least for that cross, especially the way Johnny Depp played it, right? Which was, oh, you're silly. What are you talking about? You weren't there. Such a lost opportunity. It feels like there must be some reason, or maybe the lawyer just didn't have it ready to go.
Then you went in the house and saw Mr. Depp in the foyer, correct?
Yes, correct.
And Mr. Depp was trying to urinate in the foyer, wasn't he?
No.
Mr. Depp had his out of his pants,
Objection.
didn't he?
I think I would remember
Relevance.
seeing Mr. Depp penis.
I'll allow.
Good for the judge. We're going to have all this other stuff. We're going to allow this question. We're either getting into this stuff or we're not. So
And you were trying to get Mr. Depp out of the house, correct?
Correct, I was trying to get Mr. Depp out of the house, yes.
And Mr. Depp was refusing to leave the house, was he not?
Not so much refused, he just wanted 2 minutes to say his piece.
So here's the thing. If you're going to level an allegation in front of the jury that Johnny Depp was trying to pee in the foyer, right? I don't think you can skate past it because your credibility matters. You're standing there on behalf of your client. The jury has to be able to trust you. He throws it out. She allows the question. It's never stopped. You got Johnny Depp laughing at you. Now you have the goods or you don't. And so it's an interesting choice to level the accusation and not have something to back it up. Now, sometimes all you have to back it up is that your client says it and they deny it. Now you got his bodyguard. If you're gonna make that accusation, I think you have to be prepared to knock it down piece by piece. You're his bodyguard. You work for him. He pays you. You heard screaming, you came in, he didn't want to leave. I think you have to at least set up because he kind of threw it out there, let it go. You got someone laughing at you. You heard someone in the courtroom laughing at. Hopefully it wasn't the jury if you're doing the cross-examination. And I think how you set it up is just as important as the question itself.
And this was taken at your apartment in Orange?
Yes.
And this is your breakfast table?
I watched a lot of this cross-examination, and this was a great cross-examination. Very well prepared, knew where she was going. If you ever just want to watch a good cross, you can watch this cross.
And it's your testimony that Mr. Depp left this breakfast table just the way you took it?
That is correct.
So this is what the table looked like after Mr. Depp had been doing cocaine?
Well, clearly he has yet to snort these lines.
I don't remember this part, and I didn't watch every drop of the cross-examination. I watched a bunch of pieces of it. She's going somewhere. Let's go for the ride.
There are 4 lines of cocaine on this table, right, Ms. Heard?
In this picture, I see 4 lines.
There isn't any cocaine residue around those lines, right?
Not that I can tell, no.
Doesn't really look like Mr. Depp or anyone was doing cocaine off that table, does it?
I beg to differ with you on that. When you snort cocaine, typically it goes into your nose.
And there's
doesn't stay
residue.
on the table.
There's residue from that cocaine when your lips and nose touch the table, right?
Well, the tampon applicator next to the driver's license that you see is a device that I believe my sister had taught him to use in order to put the cocaine in your nose.
Where do you think she was going with that?
The point of the cross-examination is to say you set this up. You tried to make it look like you took a picture, Johnny Depp after the fact, and now you're trying to, but why would he line the cocaine up, have it ready to go, and then not snort the cocaine, right? So she's saying in cross-examination, you're doing a setup, and you're trying to make it look like cocaine was already done, but if any cocaine had been done on that table before those lines, you would see residue. So that is after Johnny Depp left. You put in 4 lines of cocaine and made it look like he was either about to do cocaine or had done cocaine, but he hadn't done cocaine because there'd be residue if he had done it at any point. So now what you're saying is he lined up 4 lines of cocaine, even though he had done none and then left. However, at least in that clip, she doesn't say it. And you would expect that you would go, okay, thank you. So just to be clear, I want to make sure we're clear. That applicator is something your sister taught him. So how old was Johnny Depp at that point? How long had he been in the industry? You've alleged he did drugs. He didn't know that this was a better way to do cocaine. So your sister actually taught him a better way to do cocaine than he'd ever known before. Now, you took a picture to try to show all the cocaine. You wanted a picture for a reason, right? You chose to take the picture. You didn't know you were gonna do an op-ed and get sued, right? So you said you took this picture and you were trying to document something. But let me ask you something. If someone has been drinking, they may stop drinking, but usually people would not open a drink, right? And then stop. Doesn't matter what she says. Now, you see no evidence that any lines of cocaine have been done before those 4 were laid out. Do you see any residue suggesting that a single line of cocaine had been done? And you would expect if even 1 line of cocaine had been done, that there would be some residue even if more cocaine was passed over it, right? You understand that. Your opinion is he laid out 4 lines of cocaine having done none and then just left. She didn't go there. Maybe she thought, my point is made, this woman has no credibility. I don't know, but I do think that's what she was trying to say. I will say part of the fun of cross, though, is that part, which maybe she did later, which is to just hammer home that your story makes no sense. But sometimes you're like, I'm gonna let the jury figure this out. So I don't know why we didn't get the next fun part out of that.
So why did you go over to the penthouses on May 21st, 2016?
Ms. Hurley requested that I come over to have a talk.
By the way, for those who are not following, because the screens look like they're both testifying, Johnny Depp is being asked questions by his own lawyer. It's called direct examination. Amber Heard, and she countersued, right? So you have both these lawsuits going on. She's actually sitting at counsel table. The reason there's a mic is sometimes counsel needs to talk to the judge and it needs to get captured on the record.
She brought up the situation of the fecal matter on the bed, and she tried to blame it on the dogs.
Do you recall what time approximately you arrived at the Parker Hotel on April 22nd?
Around 5:30-ish, maybe 5:45.
And did you have any discussions with Miss Heard on the way to Coachella that evening?
We had a conversation pertaining to the surprise she left in the boss's bed prior to leaving the apartment.
And when you refer to the surprise in the boss's bed, what are you referring to?
The defecation.
And what did Miss Heard say about the defecation in Mr. Depp's bed?
A horrible practical joke gone wrong.
This is actually where judges matter. I'm not saying the judge made the wrong call, but where judges matter. So allegedly Amber Heard crapped on Johnny Depp's bed. Now they're suing each other, defamation related, civil claims related. This is one incident allegedly that happened between them. Some judges would go, I am not going to allow multiple witnesses and all this detail on something that doesn't relate more directly to why we're here. And some judges would go, no way. You're making accusations against each other. This is a pretty big deal. The jury has a right to know. I am not in a position really to say the judge made the right or wrong decision. And regardless, when it comes to admitting evidence, it's an abuse of discretion. In plain English, the judge has a lot of latitude to decide what the court's going to allow the jury to hear. But you can see this became a really big deal, right? And it does matter because if everyone thinks Johnny Depp got him and his driver and people related to him to make this up, he loses a ton of credibility. If they believe it, she doesn't exactly come across as the stable abuse victim. And of course, in this context, people lose any sense of anything other than, you know, what's out of the norm and so forth. So it gets totally blown up and becomes a huge issue of conversation. So now we have multiple different witnesses being asked about the same exact issue that does not even drive at all to the core of why they're suing each other.
And isn't it true that in the entire time you were there, you were not informed as to what caused damage to Mr. Depp's finger on March 8th?
Objection, hearsay.
I'll sustain the objection. Next question.
You didn't know what could cause damage to Mr. Depp's hand while you were there on March 8th, correct?
Dr. Kipper told me he sustained an injury on one of his fingers.
Objection, hearsay.
Wait, you asked the question.
Oh.
So the correct thing to do really quickly is, if the judge is going to say, and I get it, you asked the question, yes, but I asked, did he know? He answered with hearsay. So you could, in theory, move to strike because the answer's hearsay. Now, the judge is probably going to go, you asked an open-ended question, so you got what you wanted, which is funny because a minute before he thought that's not what the witness was going to say, so I'm not sure what was going on there with the lawyer.
Where that Mr. Depp has testified under oath that he would not take another Pirates of the Caribbean franchise role for $300 million and 1 million alpacas. Now, would Disney entertain paying Mr. Depp more than $300 million and provide him with more than 1 million alpacas to be able to obtain his services for any future Pirates of the Caribbean role? No.
Sometimes you wonder, and we're all guilty of this as trial lawyers. If you've ever sat on a jury, you've watched lawyers go into stuff that not a single person on the jury cared about, and you wonder why the lawyers do that. I can tell you why, because we live these cases for years, and we're afraid that any fact that might matter doesn't come out to you, and so we make you want to shoot us. And that is some of that questioning.
Did I read that right?
Again. Say
Did I read that right?
again. I dare you. I double dare you, mother.
Negative publicity about Mr. Depp being publicly drunk before the op-ed, correct?
There was, I agree with the proposition that there was negative publicity before the op-ed. The op-ed was something different.
And you agree, in 2014, there was an article in The Guardian that said apparently drunk Johnny Depp cut off at Hollywood Film Awards ceremony. Would you agree with that?
Again, I don't remember reading the Guardian.
By the way, just for those who are wondering, just to make sure you understand, there's two kinds of witnesses in a trial. There are fact witnesses, okay, and there are expert witnesses. An expert witness did not observe anything. An expert witness is brought in to share things with the jury that the jury doesn't know on their own. So this is an expert witness paid to be there and handpicked by Johnny Depp's team. Don't worry, the other team got a chance to do that too, whether they chose to or not. The other side gets an expert, you have a chance to pick your expert. But that's who's testifying. This is someone everyone in the court, including the jury, knows is there to explain things that the jury may not understand without an expert being there.
And you remember in looking through all the documents that you saw an article that Johnny Depp allegedly showed up drunk to movie premiere, reports say, right? That was in 2017.
I think I've testified that there is certainly Johnny Depp behavior and negativity out there. Yes.
And that a family production studio like Disney wouldn't want to be associated with, correct?
Right, because a major studio would never work with a celebrity that makes them millions and millions and millions and millions and millions of dollars if they have some embarrassing behavior. We have never seen that. It must not have been the op-ed.
A series of 5 films that earn billions of dollars.
Sorry, billions, my bad.
And there is a line in Hollywood, as I've said, they'll put up with divas and drugs to make money, but now we've drawn a line in Hollywood at the domestic and sexual abuse.
And in looking through the documents, you saw articles in June of 2018 that said vodka for breakfast, 72-hour drug binges, and spending sprees that beggar belief. You saw that?
Right or wrong, this lawyer has decided that he can undermine the idea that Johnny Depp lost work for an op-ed piece saying he was abusing Amber Heard by going to the fact that he had drunken disorderly behavior. When this witness calmly is trying to undermine that, the lawyer is not coming back at what he's saying. He's just moving on to his next question. And you know the witness may go here because this is their expert. They've literally hired a guy who can sit there calmly and say why the op-ed piece is what cost Johnny Depp millions. You know where he's going, right? So when he goes there, if you just keep going through your set of questions that he's already rebutted, you lose potentially the attention of the jury and the credibility with the jury. So come back at him or move on to something else. You know, use examples. It is not effective when a witness has already picked apart your point to continue to march down your list. When you're on cross, you need to be agile and adjust to what's being said.
I know these articles exist. I know they're not in the Washington Post. I don't know what article you're referring to, who wrote it, what publication it was in, but I know that those articles exist.
And you'd agree that before the op-ed, Mr. Depp had a run of movie flops, wouldn't you agree?
Again, this goes back to my issue before with Cross. If you say something to me like, well, I don't know who wrote that or where it exists. All right, well, exhibit 462, LA Times, author such and such, this date, that's what was said. You can cross-examine with a banana peel. It may not come into evidence, but generally, if a witness says, well, I don't even know where it exists. All right, well, I do, because I'm ready to go.
Quote, has Johnny Depp become Hollywood's biggest joke?
I don't know, Netflix has a whole festival going now. Netflix is a joke.
And you'd agree that there is an article in Business Insider from 2015 that says Johnny Depp has his 5th box office bomb in a row.
If that's what it said, it said. Are you just going to keep reading this?
Well, I mean, this is Mr. Depp's reputation. That's what you're talking about in terms of Hollywood, correct? And in 2016, December of 2016, there's a quote.
By the way, you didn't make him answer the question. He asked the question and kept moving. But at least he did it as a question, because we've seen in some of these where some lawyers make a statement, which you're not allowed to do. He asked it as a question. He just didn't let him answer.
Article that says, quote, Johnny Depp is Hollywood's most overpaid actor for the 2nd year in a row. Did you recall reading that?
I don't know, was that written by the second?
I'm not sure if Johnny Depp just said that's right.
Underpaid actor? Or
and you would agree that before the op-ed, there was negative publicity for Mr. Depp about assassinating President Trump. Would you agree?
No, I missed that one.
You didn't see an article in the New York Times that said Johnny Depp flirts with idea of Trump assassination, then apologizes?
Again, Johnny Depp talks with irony and panache, and I don't particularly remember that. I have a lot of stuff in front of me.
Disney wouldn't want to be involved with somebody who's calling for the assassination of the president, would it?
I'm sure after those articles, Johnny Depp was involved in a major studio project.
If you watch this line of questioning, a lot of this is objectionable, because saying Disney wouldn't want to be involved in that calls for speculation. He's not there for Disney, right? Now, he is an expert, and he could probably speak to, generally speaking, do you have a basis for whether Disney has ever been willing to work with someone who's had alleged willingness to assassinate a president, things along those lines. I think that what you're seeing is Depp's attorneys at this moment are like, he's doing no damage. We'll let our witness go. We got nothing to hide. We're good.
If you don't have information that's helpful to this case, then you wouldn't be a witness, correct?
Objection. Calls for speculation.
Sustained.
100% calls for speculation. I don't know why I'm stuck here. You called me here.
You know this case is being televised, right?
I am aware that there are cameras.
And so this gets you your 15 minutes of fame, doesn't
Objection, Your Honor. Argumentative.
I can ask that question.
Overruled.
So I stand to gain nothing from this. I'm actually putting myself kind of in a target of TMZ, a very litigious organization, and I'm not seeking any 15 minutes here. Though you're welcome to speculate. I could say the same thing by taking Amber Heard as a client for you.
A little argumentative, don't you think?
Oh, hardly. I find that to be purely logical.
I mean, fair game, right?
You compared pirates to the to the depositions given in this case.
Then I apologize for what I said. Then I misspoke.
You misspoke? You didn't make the comparison?
Right now, just a second ago? Just a second ago, I may have said that I misspoke. I apologize, I misspoke.
Okay. Because you know you can't compare pirates to sworn testimony, right?
Yes.
Here's the problem. If he did in fact do that earlier, which sounds like he did, as an expert witness, saying, I've watched Pirates of the Caribbean and I've watched his testimony and he's acting. Don't put it in your report. But if you're going to, lean into it. Well, yes, I can. Because he was acting in both cases. Because we see signs of telling the truth and we know exactly what it looks like when he's an actor. And he's acting the same way he testifies. So yes, in fact, in this case, you can see obvious signs that what it looks like when Johnny Depp is acting. Because acting is actually not telling the truth, is it? So here he runs away from it. Now, I would say that probably trying to say a movie gives you enough information to say that someone lied in a deposition, probably not something to put in your report. Now you're backing down on the stand. That's a credibility piece, right? Which is probably the biggest reminder as an expert or anyone. Be careful how far you go when you're not cross-examined, because you're gonna have to stand up for what you said.
You can't judge someone's processing speed at any time. Like I'm judging yours right now, you're judging mine. We all judge processing speed as a baseline because of what we know about each other. And I would say your processing speed right now is not slow. So, I mean, we're judging processing speed, I'm just saying.
Yeah. But no, any of Mr. Depp's other portrayals.
You see the lawyers, the main lawyer sitting next to Johnny Depp, just look at the jury like, what the hell did he just say? The funny thing is the jury is always watching. I talk about this with my clients. From the time you leave home until you're back in your home, you should assume the jury is watching. When he looked over at that jury, he may have actually thought this wasn't a great moment for him. I don't know what he was thinking, but he was looking at the jury like, this is BS, right?
In movies, did that affect your analysis of processing speed?
Only I've seen him interact on interviews, and that was it.
Right.
When he wasn't in movies.
Right. But Willy Wonka doesn't matter to you? You see him in that movie, Charlie and Chocolate Factory? Did you look at that one when you were comparing his processing speed?
Not what you want your expert doing. By the way, can I just say this? If it isn't for places like Law and Crime Channel actually putting this stuff together, we never get it out here to have these discussions. So thank you to Law and Crime. This is a lot of work they do, especially on a trial that was this big. And to put it together so we can have these discussions is awesome. I love that channels like this are out there to make a difference so we can get into these courtrooms together.
Do I have to answer that?
Looking to the judge for help, not a good look from your expert. You do not want your expert looking to the judge like, save me, let alone whatever he just did with his face, whatever that was.
You made a very kind admission, I think, early on in your deposition, that you're not claiming to be a better actor than Mr. Depp. That's correct, isn't it?
100%.
See this, guys? That is a nonverbal cue of someone lying or uncomfortable with what they're saying. Do I think every time someone covers their mouth, they're lying? No, and you don't think that either. But it's so interesting. He's looking to the judge for help. He's covering his mouth. He's not confident. He doesn't think it's going well. And that means that people who are paying him ridiculous amounts of money to prepare for this trial and be there are not happy with their money spent at this moment.
And this is after he made the statements you claim are defamatory, right, Ms. Heard?
21, yes.
Ms. Heard, you tweeted at Adam Waldman, quote, Yes, Mr. Waldman, I may be wearing makeup on this occasion, but on every occasion you will still be short. Did I read that right?
Yes.
That's it. So we're just concerned that she was rude to someone who was rude to her?
A lot of people online, while this trial was happening, saw a lot of these funny moments and kind of made their opinions about things based off of just some kind of ridiculous stuff that happened inside the courtroom. How much does that play into, while we have our own opinions as a public, does any of that really factor into what the jury is thinking?
Here's the problem with social media or nightly news coverage of a trial. It's picking the parts that are interesting. They may not be the parts that matter. So the jury is sitting there for hours and hours and days. So you can pick some of this stuff and everyone goes, see, that was a critical moment in trial. When actually the critical moment in trial was when the judge allowed a potential juror to get on the jury who made clear that he or she shouldn't have been there. The critical moment of trial could be something very mundane about how the law is defined, and some expert that isn't interesting and is super boring, but actually said something where the jury's like, oh, that isn't defamation, or that is defamation based on what they said. I mean, look, we all do it because here's the truth. If right now you want cereal and you go down the cereal aisle and you're someone who doesn't have 1 or 2 cereals, you're someone like me, you could go anywhere from Rice Krispies to Honeycomb to Sugar Smacks. You can do whatever you want, get some Apple Jacks, do some Lucky Charms. You don't know what you're gonna get when you head down the aisle. You get through the aisle, you picked out 2 boxes of cereal. If you ask the person and then why they picked out the 2 boxes, Lucky Charms, Cinnamon Toast Crunch, they'll tell you, but it's not true. They're giving an explanation. They don't even know the reason. If you always get Lucky Charms, you know the reason. If you had just had someone talk to you about Apple Jacks, like, ooh, I missed those, maybe you know the reason. Why juries make their decisions is actually very complicated. There's so much information that you don't even know. So these moments that we just went over, which could have made a difference. Let's say in Virginia, because I don't remember, they have 12 people making this civil jury. You have 12 different reasons why they got where they got, or one reason why the leader got where they got and the other 11 followed the leader. And so I think you have to be super careful about the moments that are like, wow, you got him. Now, anything that undermines credibility, I think is always critical. I think no matter how far ahead you are, if you lose your credibility in trial, you could lose the case. If your client does something that makes the jury not like them, you could lose your case. There are moments that absolutely do it. Some of this stuff, though, is fun to look at, but it's snippets that probably at most made a tiny dent in what the jury actually had to consider when they came back. Listen, the Johnny Depp Amber Heard trial was the biggest civil trial during my career. I want to know, make sure, look, like it, but comment and tell us, do you want more of this? There are so many clips, and are there specific clips you want? Because my perspective's different, right? It's a little bit like, yo, I've been there. This is my kind of stuff. I'd love to jump into it. And YouTube just did you a favor. Because YouTube's like, yo, there's so much content out there. What are you supposed to look at? And YouTube's like, look at this right here. YouTube's screaming at you. Check this out. If you like this, you're going to love that. Thank you for joining us. Mark Breyer of the Husband Wife Law Team, and I will see you next time.